Welcome to my session, Alcohol Regulation, National Debate, and State Implications. I'm Cassandra Tourre, Director of Public Policy of the National Alcohol Beverage Control Association. Here's a quick overview of where we're going today. I'm going to discuss recent trends driving legislative and regulatory changes, and going to provide an overview of policy changes that are reshaping the alcohol marketplace. We're going to discuss data systems and their importance, particularly in creating the rational nexus between regulation and their intent of protecting public health and safety. And we'll turn our attention to the courts to discuss how they are impacting the policies that are shaping the alcohol marketplace today. Before we get started, I want to tell you a little bit about the organization, the National Alcohol Beverage Control Association, that I'm here representing. It is a nonprofit trade association that was established in 1938, shortly after the repeal of federal prohibition. Our governing board members are those jurisdictions that are not only state government agencies, but are state agencies that are market participants, meaning they sell at least one beverage category at either wholesale, meaning they distribute the products to retailers, or through state or agency contract stores. I'll talk more about the control jurisdictions in a moment. While many trade associations are advocacy in nature, lobbying on behalf of their members, NABCA is not. Sometimes people hear our name and think we're a beverage alcohol industry group, but we're not that either. What we are is an organization that strives to be a repository of credible information on all aspects of beverage alcohol, to be a resource for all those who seek to better understand alcohol regulation and alcohol policy. Alcohol has two references in the U.S. Constitution. The first is the 18th Amendment enacting federal prohibition, and the second is the 21st Amendment repealing federal prohibition. A criticism of federal prohibition was that we treated the entire country as though it was of one mindset on this issue, but that could not have been further from the truth. While prohibition had many enforcement challenges, it was successful at reducing the heavy consumption rate at the time. The 21st Amendment gave states the explicit power to regulate and tax alcohol as they saw fit, recognizing that each state is unique. This created a natural experiment that we're still experiencing today. This natural experiment has created a tapestry of rules and regulations across this country. When federal prohibition was lifted in 1933, states were given this authority to regulate alcohol, but they had little experience. So John D. Rockefeller Jr. commissioned two researchers, Fosdick and Scott, to conduct a study that resulted in a seminal report called Toward Liquor Control. The research team conducted more than 400 interviews throughout the world to make recommendations for how states could regulate alcohol and prevent the social ills that led to prohibition. While the book was written in 1933, it's an easy read, but I'll save you the time. Here are the quick cliff notes. They recommended that 1, states should adopt policies to reduce aggressive sales tactics that incentivized heavy alcohol consumption. 2, they should prevent vertical integration between producers and retailers, which I'll explain further in a few moments. 3, they should restrict hours, days, and outlet density to mitigate harm. And 4, place more limits on higher alcohol by volume products such as spirits. The research team identified several ways to restrict higher octane alcohol, and one way was to have government sell the product known as control systems. Fosdick and Scott, however, recommended this, but they also understood that a number of states would likely not choose this path. What has emerged, however, across the country are two primary forms of state alcohol regulatory structures, the control model and the licensing model. These names are misleading because no matter what state system you have, there are still elements of control and licensing in both systems. The element that distinguishes one from the other, however, is that under the control model, the state owns part of the alcohol business, usually wholesale or retail operations. Now, all control jurisdictions wholesale spirits. Some have wine and beer, with others having state-run stores that sell beverage alcohol. In licensed jurisdictions, alcohol is distributed and sold by the private sector. There are 17 states and several local jurisdictions in Alaska, Maryland, Minnesota, and South Dakota that operate under the control system form of alcohol regulation. And really, when you look at this map here, you're going to see that nearly 25% of the U.S. population lives in a controlled jurisdiction. But whether you live in a controlled jurisdiction like Michigan, Idaho, or North Carolina, or you live in a licensed state like South Carolina, Nebraska, or Massachusetts, all jurisdictions achieve regulatory objectives by licensing individuals to sell the product. They work to enforce laws to reduce underage and excessive drinking, as well as illegal trade practices. They regulate access to the product through restrictions on days, hours, and locations. And they require all alcohol to flow through what's known as the three-tier system of alcohol distribution. The three-tier system is the bedrock of the U.S. alcohol regulatory structure. I like to think of the structure as an hourglass with several checks and balances that provide safeguards to the consumer while ensuring a simple method to collect tax revenue. The three-tier system is simple in theory. Manufacturers or producers provide alcoholic products to the wholesalers. And then the wholesalers distribute the product to the retailers, who then sell the product to the consumer. No one entity can be involved in more than one tier under most state models, and each tier is regulated and licensed separately. The three-tier system is a safeguard for consumer protection and public safety. Before Prohibition, there was widespread issues with tied house saloons, where large manufacturers owned retailers and incentivized heavy consumption through aggressive sales tactics. They locate near factories, and often men, the primary breadwinners for their families, would write their entire paycheck over to the saloon, leaving little resources for the family. After Prohibition, to address vertical integration between producers and retailers, the wholesale tier was born. And this tier affords us many protections, as I mentioned, but particularly through collection of excise taxes and by tracking down tainted alcohol products when and if tainted products enter the marketplace. Now, the wholesale tier was intentionally created to protect the public and ensure tax collection, and it's done well. We have near 100% tax collection in this country, and very few incidents of tainted alcohol products entering the marketplace. Other countries cannot say the same. Some say we're a victim of our own success because most people don't even know the protections the system provides or know of the system to begin with at all. And as a result, there are rapidly changing alcohol policies that are shifting this environment, and in some cases threatening to undermine the system designed to protect us. All three branches of government are playing a role in these rapidly changing alcohol policies. The legislature plays a key role in creating the laws and changing existing laws that the Alcohol Regulatory Authority must then implement through rules and regulations. And the judicial branch is interpreting these laws. Recent court cases have challenged residency requirements for licensure, and others have blocked out-of-state retailers from direct shipping into state, citing public health and safety concerns. The executive branch, more recently through governors' executive actions, exercising their executive power during the COVID-19 pandemic, has expanded operational practices such as home delivery and curbside pickup to assist alcohol operators and to encourage adherence to stay-at-home orders and social distancing requirements. There are several factors driving the sweeping changes we're seeing to the alcohol marketplace, but today I want to focus on three: the recent public health crisis, the demand for e-commerce, and the federal courts. Let's first turn our attention to the public health crisis, which through governor executive action led to several changes that were initially temporary and for some states are becoming permanent through legislative action. In recent years, we have seen expansions in access points for alcohol, but the public health crisis that left us quarantined to our homes and socially distanced from one another created an environment where temporary policies were adopted to support struggling businesses, particularly restaurants, during a time that they were hit hard. This led to rapid expansions of home delivery of alcohol, mixed drinks to go with food delivery services, and curbside pickup. There were also expansions into non-traditional settings such as parks and expansions of footprints for on-premise retailers into off-premise areas such as sidewalks and parking lots, where traditionally alcohol was not readily available or permitted. Early on during the pandemic, we sought to inform our members by creating alcohol policy dashboards where we track daily changes in state alcohol policies through executive action for restaurants, bars, and off-premise retailers. Here you can see results for curbside pickup for restaurants and the variations within this policy area. We also tracked a number of variables across a range of policy areas, including home delivery of alcohol. An area of interest to the public and to our members was the availability of permitted mixed drinks to go, whether being picked up curbside or delivered to the consumer's home. These dashboards can be accessed on our website at www.nabca.org. Speaking of home delivery, we can get everything shipped and sent to our front door. E-commerce is driving all aspects of consumer purchasing these days, and alcohol was slower to get this level of access, but that's changing. A November 2020 report by the International Wine and Spirits Record, a source for global beverage alcohol trends, found that online alcohol shopping spiked in 2020, with nearly half of consumers new to buying alcohol via e-commerce. As a result, IWSR forecasts that alcohol e-commerce markets value grew by 80% in 2020, with sales across 10 major markets predicted to top $24 billion. What does e-commerce look like with alcohol, and how does it impact the three-tier system? We're going to focus on two primary forms of alcohol home delivery: direct shipment and third-party delivery services. This is a simplistic view of direct shipping of alcohol. While there is the basic structure of producers who use common carriers who then deliver the product to the consumer's home, there are several other players in the supply chain, including fulfillment houses and online third-party providers, where they store and handle logistics for shipment, where the common carrier is then used to deliver the product. Fulfillment houses are typically licensed in the state, although not always, and they are used to help producers with storage and getting the product to the consumer faster. Third-party providers are typically not licensed in a state. They are an online platform that is connecting consumers to locations where the product is sold. They also handle shipping logistics, where they are putting often contains alcohol label on the package and facilitating the transaction of sale for the product. Regardless of whether the fulfillment house or third-party provider is used, a common carrier is used to deliver the product to the consumer at their home in the direct shipping model. In this supply chain, the wholesale tier and the retail tier have been removed. If you recall, the wholesale tier is where we collect taxes and where we can track down tainted alcohol products. The retail tier is where we have trained employees ready to card the individual who is there to make the sale, but also to defend against illegal alcohol sales. When these tiers are removed from the traditional three-tier structure, policymakers have to think through how to protect consumers and how states will collect taxes in this new supply chain model. The other form of alcohol home delivery is through third-party delivery services and online sales platforms. In this supply chain structure, the tiers of the three-tier system stay intact, but instead of the consumer going to their local restaurant or area liquor store to purchase alcohol, the retailer either delivers the product to the consumer with its own employee or uses a third-party delivery service such as Uber Eats, Instacart, or DoorDash. These are just a few, to deliver the product to the end consumer. In either scenario, commonly the retailer will go into an agreement with an online platform like Drizzly to facilitate the sale and connect the consumer with their products. However, they do not take possession of the product and deliver it to the consumer. They're merely a place to purchase the product. Now, there are a number of challenges with the direct-to-consumer marketplace, including preventing unlicensed producers from shipping alcohol into a state and ensuring efficient tax collection for both excise and sales taxes. Because of the closed three-tier system, we have nearly 100% tax collection in this country, and not all countries can say that same thing. Additionally, questions remain about how illegal sales, particularly to minors, can be monitored in this new environment, and the degree to which common carrier and third-party delivery service drivers are trained to prevent these sales. There are questions surrounding how alcohol can be tracked and traced if tainted alcohol products enter the marketplace. We don't hear about tainted alcohol entering the market often in this country, but we have read headlines from Dominican Republic or Costa Rica where people died because of tainted alcohol. If we remove these traditional checks and balances afforded to consumers through the wholesale tier, in the case of direct shipping, for example, what are we putting in place to ensure the same level of protection? And last but not least are questions surrounding best practices in monitoring the alcohol home environment with regulatory and enforcement oversight. Questions remain how already overextended regulatory and enforcement resources will monitor this new environment to prevent illegal sales, ensure tax collection, and ensure fair trade practices. Now let's shift gears to discuss the courts, which in the last 2 decades has impacted alcohol regulation in a sizable way. The most recent court case that I want to turn our attention to now is one that was before the U.S. Supreme Court in 2019, Tennessee Wine and Spirits Retailers Association v. Thomas. It called into question the Tennessee durational residency requirements for licensure. The law required that in order to be eligible for a license, you had to be a resident of Tennessee for 2 years, but to renew the license, you had to be a resident for 10 years. So the question before the court was, is this law protectionist in nature, or did it have a legitimate public health and safety rationale? Ultimately, the court decided that the law was protectionist in nature and that the burden of proof was not sufficiently met to establish the public health and safety rationale. However, it is important to note the court did not question the state's use of the police powers to regulate alcohol trade, but stressed that such regulation must have a bona fide relation to protecting the public health, the public morals, or public safety. And it went on to say that each state has leeway to enact the measures that its citizens believe are appropriate to address the public health and safety effects of alcohol use and serve other legitimate interests, but it does not license the states to adopt protectionist measures with no demonstrable connection to those interests. So how do you make the demonstrable connection between the law and its public health and safety rationale? I will tell you that several states, as a result of this case, got rid of their residential requirements. However, the case in Tennessee was unique and specific, with the 2-year licensure requirement and the 10-year renewal licensing requirement. Those are not the facts in every state, but despite that fact, several states still remove the residential requirements. So how do you make that demonstrable connection to public health and safety rationale? Well, it's data collection. Collecting and analyzing current data is crucial in demonstrating effective policies. This happens through effective data collection with alcohol regulatory authorities where they track license information, including investigations, inspections, and document violations, through record management systems where records are kept and maintained for a period of time. This happens through enforcement. There are many states where the state or local police have responsibility for enforcing the administrative beverage alcohol code in addition to any criminal activities that happen in and around a licensed establishment. At the end of the day, the Alcohol Regulatory Authority, which is often the adjudicating body for licensees who violate the administrative or criminal code, should be all-knowing about illegal activities that may harm the public occurring in and outside licensed establishments. This requires resources and a high degree of collaboration and coordination between state and local agencies where ideally their record management systems talk to one another. However, alcohol enforcement resources are dwindling. In 2005, the National Highway Traffic Safety Administration reported on the role of ABC, alcohol beverage control enforcement, documented that for many states, the enforcement budgets are not increasing, they are decreasing, at the same time that licensing is expanding. Additionally, the coordination between the various levels of alcohol enforcement is often needed, given many jurisdictions rely on local law enforcement to assist in monitoring these activities, both in and outside licensed establishments. And data collection of the enforcement operations are key. If these data are not available, or if there is a breakdown in coordination, it makes it very difficult for attorneys general trying to defend a state law who rely on the data to demonstrate the connection between the law and its public health rationale. In short, data is the linchpin to provide the rational nexus or the legal basis for the regulations the state has on the books. If these don't exist, it could jeopardize important regulations that are intended to protect the public. Over the last 2 decades, national partners have succeeded in creating data collection, standardization, and sharing protocols for law enforcement agencies. These national guidelines paved the way for better systems for data collection and coordination between enforcement and other agency partners at the federal, state, and local levels. And we know this can be done for alcohol law enforcement as well. Currently, the National Liquor Law Enforcement Association, or NLLEA, is working to assess the systems being used to track alcohol outlet-related incidents and information, to see how data is currently being tracked in each state, and the coordination between state and local agencies. Following the assessment, NLEA will write a report making recommendations and charting a path forward for how to improve data collection processes for both alcohol regulatory authorities and alcohol law enforcement to help improve the mechanisms of data collection that are so important to supporting the laws on the books. Turning our attention to resources, this chart reflects a more recent analysis of a sample of states' compliance monitoring capacity conducted by the National Liquor Law Enforcement Association. Now, NLEA was measuring compliance capacity by alcohol outlet agent ratio. And so the average agent to outlet ratio in the US is 1 agent for every 557 outlets. However, you can see by this chart, for the states that participated in an NLLEA survey, some have nearly tripled the number of outlets for 1 agent. This can make it very challenging to conduct regular and routine monitoring of alcohol licensee compliances, and can complicate data collection when agents are overburdened. Yet there are states that are using data to their advantage to assist with their resource challenges and positioning their AGs with strong data for any future court cases that may come. The Vermont Department of Liquor and Lottery Division of Liquor Control has created a predictive modeling tool known as Project Rabbit, which stands for a resource allocation based on an intelligence toolkit. It's comprised of 2 applications, a mobile app to collect data and software to visualize, interpret, and drive decision-making. It allows for data-driven allocation of DLC resources to areas of the state and to licensees that need education and/or enforcement attention. When they first started using this tool a few years back, in just a 6-month period of using it, the DLC went from a 2% violation identification rate to 15%. And again, they first focused on educating licensees before they moved to adjudication and enforcement of those violations. I want to leave you with the pillars of alcohol regulation: protect, ensure, eliminate, and balance. First and foremost, alcohol regulation exists to protect public health and safety and to ensure efficient tax and revenue collections. Remember, we have near 100% excise tax collection in this country. Our systems to date have been very efficient in ensuring this tax collection. Additionally, alcohol regulators need to work to eliminate unfair or illegal marketing practices and trade practice violations among industry participants. Alcohol law enforcement is critical to ensuring a fair marketplace. Alcohol regulators must also work to balance a variety of interests, and this might be their most challenging task. Whether that be interest between the tiers, producers, wholesalers, and retailers, or interest between small craft producers compared to multinational producers, or that between on-premise and off-premise retailers. But they also have to balance public health and safety in that context. And it is a challenging task before them, but it is a worthwhile one. And these are the pillars of alcohol regulation that we should remember as states debate and look to change alcohol regulation across the country.